All right, looks like we're live. Thanks for following me. Hopefully the connection is holding up and the audio isn't muted. I'm John Bryan, West Virginia civil rights lawyer. And if you've been watching my videos and following what I've been doing, you know that I've been fighting against the gubernatorial tyranny that's been occurring here in West Virginia and elsewhere, where governors, and unfortunately, one of the worst states, believe it or not, where this has happened is West Virginia. And really the complete opposite of one of our sister red states, the state of South Dakota, where in South Dakota, the wonderful governor over there has given her, and I say that facetiously because, as she has said, it's not her power to give, but she's allowed her residents the freedom of making their own decisions, such as the situation. Or you go to the state of Florida, where I grew up, and even though it's nowhere near a solid red state or a solid blue state, it's always been sort of tangling and fighting in between. Everything's open. There are no restrictions. Does that mean that nobody's wearing masks or nobody's social distancing or nobody is caring for their neighbors or caring for their family members? Does it mean that everybody is bringing home sickness and death to their grandmother? No, absolutely not. Because we don't need a morbidly obese governor who can't handle his own caloric intake lecturing us on health, period. And it's not just about the person, because again, I'm being facetious here. It's about government. It's about government. We don't need government to tell us what to eat. Remember with the food pyramid, remember with Michelle Obama's school lunch program. We don't need the government to tell us what to eat. We're perfectly capable of coming to those decisions on our own. But just like anything, whenever you start to rely on the government for food, they get to then tell you what kind of food you're going to eat, what kind of food you should eat. Likewise, when you depend on the government or give them power over your health care, look what happens. Look where we're at. Remember back when Obamacare was first being discussed, and socialized medicine has always been discussed, going back decades. Really, part of the conversation hasn't been, well, what are the consequences to our liberty? What's our what freedoms are we going to be giving up if we have receive health care from the government? I don't think the only discussions were really, well, you might lose your doctor, but you can keep your doctor if you want to keep your doctor. Of course, that was a lie. But look at all the insidious things that comes with letting the government into your health care. They get to say how old you get to be, whether or not you get certain treatments to prolong your life, or whether you've just lived long enough. They get to say whether you have to wear certain things, such as a mask. They get to say whether you have to be injected with certain substances. And the list goes on, but it all starts with giving government an inroads into your health care. So instead of you getting to make decisions with your doctor, now you've got government inserting itself into the process, and you have people who, like our morbidly obese governor. And again, that's not, that's a scientific term. Or you look at the guy that is making decisions in Pennsylvania. Take a look, go Google that. The head state health person in Pennsylvania. Or in some of these other states, you have just people who obviously are not well balanced mentally, or they are not able to make their own healthy decisions, not just lecturing us, but mandating us on things that should be personal decisions between us and our medical professionals, and the medical professionals we choose to hire or we choose to consult. But here we are in 2020, when we've really seen the end result of if we keep going down the road of socialized medicine. Not only do we have to wait for a surgery like they do in Canada or in the United Kingdom, it may be free, but you have to, I mean, nothing's free. So you have to wait and wait. You get on a waiting list. And you have people in the past coming to the United States for medical treatment that they had to pay for rather than to wait in their socialized healthcare system for the free procedure. Now, what does this have to do with what's going on here? Well, with all the mandate tyranny, we're seeing these public health officials run amok. They're drunk with power. They're intoxicated with power. And they've been out of control in pretty much every state, in almost every state, especially here in West Virginia. So I filed a federal lawsuit on behalf of a restaurant in Putnam County, West Virginia. That's the Bridge Cafe and Bistro. And it wasn't just about them. They just stepped up. Because what I'm going to get to is the response was filed by the governor through his lawyers. And several times in the response, he just bashes this little restaurant that he had made to suffer through his lockdown. He bashes them just for standing up for their liberty, for asking for due process. He bashes them, calls them small. In fact, you can see, I'll show you, this is the governor's response. So his response, when you file an answer to a lawsuit, you can file a motion to dismiss, or you can file an answer. But you don't have to file an answer if you file a motion to dismiss. And what that is just asking the judge to dismiss the case on the grounds that even if everything that the plaintiff in the lawsuit says is true, as a matter of law, there's no case there, so therefore it should be dismissed. And I knew that they would file one because we had already been in court once, and the judge had indicated that they were going to file a motion to dismiss. So here is the motion to dismiss the lawsuit that was filed by the restaurant in Putnam County, West Virginia. But you can see how they begin this. On this hallowed day in 1941, again, they filed this on Pearl Harbor. On this hallowed day in 1941, more than 2,400 Americans perished in the attack on Pearl Harbor. Today, on average, more Americans die each day from the COVID-19 pandemic. But this lawsuit is not about them. It's about erasing West Virginia's efforts to protect the public health from that deadly pandemic because the owners of a small restaurant in Putnam County don't want to wear masks. Or comply with the governor's directives regarding masks. The legal rights the plaintiffs say give rise to this action are not limitless and come with legal responsibilities and duties. Oh, really? And what are those? And where can we read these? Their claims thus fail as a matter of law. So it's a small restaurant. They just don't want to wear masks. They just don't want to comply. This is basically Pearl Harbor every day. And the governor does have limits on what he can do. So therefore, the plaintiffs must lose. Well, what are the limits? What limits does the governor have? That's what all this is about. There are no limits. What are the limits? Where can I read these limits? You'll see that the governor's claim is that to the federal courts, there's nothing that you can do. And that's consistent with the rulings in federal courts across this country, unfortunately. But there's nothing that you can do because there's no federal constitutional rights that are implicated by governors reacting to any emergency. And that just absolutely cannot be true because our country was born in an emergency. And how could our founding fathers not put an exception in there for times of emergency when all they had lived through was emergency? So the argument is that anytime there's an emergency, which is defined by numbers of deaths, you see why they're focusing on statistics. So because you have this number of deaths, either here or elsewhere, then government must act to protect people. Well, if that's the standard, and I missed in the Constitution where it stated that these rights only apply so long as everybody's safe. That's never been the case, and that never should be the case. In fact, our state constitution here in West Virginia, which I've pointed out so many times, and nobody really cares, it says that it applies all the time, 100% of the time, 24/7, 7 days a week, and will never be suspended, not even in a time of war. So does that mean that although it won't be suspended in a time of war, if we have a pandemic that's bad enough, then they will be suspended? No. In a time of war. And the governor has actually taken that during some of his news conferences, and he said, we have to look at this like we're fighting a war, like the enemies at the borders. You know, it's not a war. It's not a war. And I don't know that if it was a war, I think we would have gotten our ass kicked a long time ago. We'd already be speaking Chinese by now. Because what has government done to stop it? They can't stop it. It's a virus. When have they ever been able to stop the flu? The flu's killed people. Wouldn't it have been nice if they held this power the entire time? But they allowed lots of people's grandparents to die of the flu in previous years, and probably many otherwise healthy people. Since the mask mandate, the numbers have skyrocketed. Prior to the mask mandate, the numbers were pretty nominal. But it doesn't matter. You deny science. You don't believe in science. But when we look at the science, when we look at the statistics, they've gone up, up, up. They've skyrocketed ever since the mandates. Everybody's wearing masks around West Virginia these days in all the stores. Everybody's wearing masks. In fact, it's rare to see somebody without a mask now. And I didn't even think I'd end up see it that way. And yet the numbers continue to go up, almost like it has nothing to do with it. Like it's going to do what it's going to do, whether or not you wear a mask. It's almost like the virus doesn't care whether you wear a mask, which makes sense because where did we see the outbreaks early on? Exactly where people were wearing masks, in the nursing homes. That's where it first spread around West Virginia. And almost all the initial deaths, they were all in nursing homes where there were already requirements in place to wear masks. They spread in hospitals where people are already wearing masks. So if we look at the science, it doesn't prove at all that this is something necessary that has to be done to save lives. That's just not the case. The only science that the governor's presented in this case are two affidavits, one from the head of the Department of Health and Human Resources, basically swearing under oath that he has all this experience and he's never seen anything so bad. Therefore, he thinks it's necessary to comply with all these requirements that the governor is outlining in his executive orders. Then there's an affidavit from our so-called COVID czar. And I'm not sure when it started to be a thing in our democratic republic to have czars over anything. Czars are dictators that they had in Russia. And czars were known for their ability to do anything and everything they want without any restrictions. So why would we want a czar over anything? That's besides the point. But the other affidavit was from a czar, the COVID czar, who was the head so-called public health doctor in the state, outlining, how what his experience is and how bad the pandemic is and why he thinks it's so necessary to engage in all these mandates and restrictions. But how is that? I mean, that's literally not even science. I mean, that's just direct testimony. That's just opinion. I mean, two doctors can have two different opinions. Two public health bureaucrats could have two different opinions, though they probably wouldn't. The fact is there's really very little science being involved, and science can be disputed. And where it is disputed, and where there's differing opinions, it's almost like we should have some sort of body, maybe a legislative body, and we could elect people, and we could have districts where everybody in a district could vote to who they want to be elected as their representative to go into this legislative body, and they could look at these facts or look at this science, these opinions, and they could debate these things, and they could engage in fact finding, and ultimately they could vote on things. And since we elected them, they're sort of like our voice, our votes, and that way we're included in this process. It's almost like we should have some sort of legislature, which if there needs to be a new law stating that everybody has to wear a face covering for any reason, could be an N95 mask, could just be a bandana, or it could be a burqa. If we're going to pass a law that everybody's got to wear this now outside their own home, it's almost like we should have a vote on it. But no, we can't vote because it's an emergency. It's a state of emergency. We have to act now. We have to act quickly. We have to act more quickly than our legislature can be called. Putting aside the fact that our Constitution says that you can only enact laws through the legislature, and that the Constitution shall never be suspended, and that the governor cannot create legislation, we don't really need to follow that, because it's just such an emergency. It's like Pearl Harbor. It's like Pearl Harbor every day. And this is just a small restaurant. You're just a small restaurant. You're just a peasant, a peon, and nobody cares whether or not you want to wear a mask. And, from the beginning of this, it had nothing to do about not wanting to wear a mask because we just don't want to wear a mask. And people have been free to wear masks all they want. The fact is what people are objecting to is the government mandating via the governor that people have to wear a mask or else be arrested and thrown in jail. That's a whole lot different. That's not just they don't want to wear a mask. That is it's a whole lot of things. Because it's not just about the substance of it, it's about the process to get to it. When we have a process that's enshrined in a constitution and it's just thrown aside, we don't follow the process, then we allow other things to happen. Look at all this voting situation. You had the voting laws changed because of the pandemic, because of safety reasons. And then look at the results. Widespread chaos. Half the country thinks that the election was stolen. Well, what was the remedy that was offered by many of the states, including the Attorney General of our state? Well, it was the argument that some of the votes should be thrown out and decertified because the governor or the executive branch can't just on their own change the voting laws that were established by the legislature. They can't do that. That's in violation of all those states' constitutions, which in turn violates our federal constitution, our right to vote. Well, a lot of the same people making those arguments are perfectly fine with it in the context of something they agree with, like making other people wear masks or closing down restaurants or whatever the case may be. So get it through your head. It's not about the inconvenience of wearing a mask. It's about the protection of liberty. Because if you allow liberty to be taken, even without the legislature, just by one man, even in situations where the Constitution says it can't happen, then you allow anything and everything. If you allow them to make you to a governor to mandate mask wearing under threat of arrest, you allow a governor to mandate forced vaccinations. You allow a governor to mandate rounding people up who haven't taken a certain vaccination or who meet any other criteria and putting them in some sort of concentration camp. It's not a stretch. If you ever wondered how the people of Germany allowed things to get to the situation that they reached towards the end of World War II, you can't be wondering much now. It only took 14 days for people to fall in line and close their businesses when the government told them to close their businesses, and to be afraid to go to their neighbor's business because the government told them that they weren't allowed to. In fact, it's been a terrifying constriction of civil liberties that's happened just in 2020. And this is the civil rights issue of our time, is the restriction of civil liberties unilaterally just by governors across the state, across the country. And I really didn't think it would have been as bad as it was here in West Virginia. But the governor went ahead anyways because he's listening to his czar. He's listening to these public health officials who are government employees who, if you look at the numbers, overwhelmingly donate to one side of the political equation, and who are seizing this opportunity to increase their own power. And look what it's done with people like Dr. Fauci. And these are people who are unelected. Now, the governor is elected, but he's elected to enforce law, just like the president is elected to enforce law. Who do we elect to be our voice to debate and enact laws? Either Congress on the federal level or the state legislature, either in West Virginia, either the House of Delegates or the Senate on the state level. We didn't vote for the governor to create new laws. We voted for him to administrate and enforce the laws that have already been set in place by the state legislature. So the governor's defense is basically that there's nothing that the federal courts can do. You can't stop me. They just go over the numbers. They go over the numbers. This is how dangerous it is. This is how many deaths we've had. Looking back at their motion to dismiss, here's what they rely on. Jacobson. See this? Jacobson versus Commonwealth of Massachusetts. That's a 1905 U.S. Supreme Court case that was challenging the forced vaccination of Mr. Jacobson by the Commonwealth of Massachusetts. And the issue before the Supreme Court back in 1905 is whether it was unconstitutional federally for a state to be forcing a vaccination on this guy, Jacobson. And the decision, as you probably know back then, was that there was no federal constitutional right not to be subjected to a vaccination by a state. And that 1905 decision, which really never came up again, has been used by all these governors and used by the federal courts to substantiate the actions of all of these governors. So we filed a response just here today. We finished it. And here's the response, just newly uploaded. Let's see. All right, plaintiff's response to defendant Governor Justice's motion to dismiss. All right, so we're challenging not just the so-called mask mandate, but also the stay-at-home order. So the lockdown itself, as it pertains to people like the plaintiffs, the small restaurants that have been hit the hardest. So our governor issued on March 16th, mind you, the stay-at-home order, Executive Order 920, ordering West Virginia residents to stay home for non-essential businesses and operations to cease operations, for essential businesses to continue operations. And then they got to further dictate and did dictate which businesses were essential under the order. And eventually that turned into what we have now is just the governor maintains a website where he can say, all right, these are the rules if you're a restaurant. These are the rules if you're a hair salon. These are the rules if you're a retail outlet, whatever. They've got rules for everybody. And this is all, the source for it is just on the governor's website. And then you have some law enforcement officials and then some local boards of health enforcing these things. And when you ask them, well, where does it come from? They just point you to the governor's website. So then after the stay-at-home order describing who could stay open and who couldn't, on July 6th, 2020, the governor issued the mask mandate in its first version. So statewide indoor face covering. And here's the thing, it doesn't matter if it's an effective mask. It doesn't have to be effective to stop particles of a virus going into your mouth or leaving your mouth into the public space. It just has to look like a mask. It could be a bandana that stops nothing. It could be just some sort of neck gaiter, or it could be a mask that is more effective, like an N95 mask or even a respirator. But it doesn't matter. The important thing is not that it works or does anything. The important thing is that you comply with it. So the plaintiffs in the case, Bridge Cafe and Bistro, that's in Hurricane, West Virginia, they followed the governor's stay-at-home order. They suffered closure as a, quote, non-essential business, and they reopened eventually when limited reopenings of restaurants were allowed by the governor as per his website and what he called the comeback, West Virginia's reopening. And actually, things have gotten just so much, worse. Things have gotten worse since the comeback. The numbers have gotten worse and worse after the comeback started. And so if the lockdown ever worked, why haven't they done the lockdown again? Well, the reason they haven't done the lockdown again, I would speculate, is that it was an absolute disaster. It was an absolute disaster. And it's almost like there's nothing that the government can do to control this virus. Except, what's the one thing that, in common sense wise, what's the one thing that you could do to stop a virus? Well, you could stop it from crossing the border. If you're an island, you just shut off your island, shut off your borders. That's the one thing that could be done, is to stop the borders. But we didn't do that. And I don't know that a state governor could constitutionally do that. And they couldn't constitutionally do that under the federal constitution. But that's the one thing you could do. Otherwise, it's going to run its course as it's done. And you can say that that's bad science, but the science is what's happened. The fact is it's spread. It's continuing to spread, and it doesn't seem that any of these governors have been able to force it out of their states. And you can compare Florida, which has no restrictions in place, and you can compare New York, which has just draconian restrictions, and Florida has better numbers. And that was in the news, believe it or not, a little while back. All right, so getting to the facts, back to Jacobson. That's what all these governors have been using, Jacobson. So the funny thing is that after we went to court on this initially, and so that was on the emergency relief that we were asking for, that's what was used, was Jacobson. And that's what they brought up again. But since then, the Supreme Court or several justices have actually discussed Jacobson and minimized its application. So Jacobson versus Massachusetts, again, 1905. That's really what's been cited by all of these courts around the country to support these mandate restrictions. It's a relic of jurisprudence that the Supreme Court had long since abandoned until early 2020, when governors across the country dusted Jacobson off and brought it back to life support to their lockdown measures. Okay, a lot of people have the opinion that courts have grossly misread Jacobson, mistakenly grafting the case onto modern constitutional precedent. But in reality, it was pronounced long before the Bill of Rights were incorporated against the states or the court developing its own modern tiers of scrutiny, like rational basis scrutiny or strict scrutiny. And it has no relevance, even during a pandemic. But here's the important thing, in my opinion, is that Jacobson actually declares that even when states are exercising police powers, as the 1905 Jacobson court called them, in an emergency, the states are still limited by constitutional rights. And when have they acknowledged that? They haven't acknowledged that at all. Their position has been, and our governor's position continues to be, that there's no limitation. There are no constitutional rights to executive emergency actions, so long as the danger is real enough and there's this safety threat. They can take any action so long as they can tie it to an attempt to fight that danger, whether it's a pandemic or whatever. So Jacobson gives broad latitude to public health officials. All right, who's calling me at 6:30? The public health broad latitude to public health officials during a pandemic, provided those broad limits are not exceeded. All right. It's been allowed for pretty much everything. But then we had Justice Alito earlier this year, where he said that Jacobson deference likely does not even apply where statewide measures of indefinite duration are challenged under the First Amendment or other provisions that are not at issue. On November 12th, just recently, Justice Alito gave a speech to the Federalist Society. He noted that Jacobson's primary holding rejected a substantive due process challenge to a local measure that targeted a problem of limited scope. It did not involve sweeping restrictions imposed across the country for an extended period of time. And it does not mean that whenever there's an emergency, executive officials have unlimited, unreviewable discretion. Therefore, Jacobson can't be read, at least in the opinion of Justice Alito, and on the facts of what it holds, it cannot be read to allow for the suspension of any existing constitutional rights or constitutional restrictions. It just doesn't. Really, it's just federal deference to some sort of state action in response to an emergency, assuming that state action has constitutional authority in that state. And that's the part they've been leaving out of all of these. We recently had the case November 25th, 2020, the New York case against Cuomo striking down the religious restrictions in New York City, or in New York. Yeah, New York City. Enjoining Cuomo from enforcing restrictions on religious services in his executive orders. The court held in the opinion that members of this court, the Supreme Court, are not public health experts, and we should respect the judgment of those with special expertise and responsibility in this area. But even in a pandemic, the Constitution cannot be put away and forgotten. Okay. Nobody seems to have told the West Virginia governor about this yet, though. What I thought was interesting and relevant in that opinion was Justice Gorsuch wrote a concurring opinion, and he noted that during this pandemic, that certain states, like West Virginia, seem to have ignored the principle that the government is not free to disregard the Constitution in a time of crisis. And I quoted a lot of it, and I would urge you to go in and read that, because again, he narrows and minimizes the application of Jacobson and the ability of state governments to go absolutely tyrannical with their mandate restrictions in light of, just using the case of Jacobson as their authority. But all of this really assumes that there's some sort of legal state action to begin with. It wasn't an issue in Jacobson that the state of Massachusetts, following the proper channels and due process of law, had the constitutional authority to do under state law what they were doing. That was assumed. It wasn't an issue. Unlike that, we are disputing that there is any state authority for the West Virginia governor to unilaterally create new laws that require you to wear anything on your face under penalty of being arrested and thrown in jail for a year. He just can't. That is just on its face not supported, not authorized by the West Virginia state constitution. And it couldn't be authorized by the West Virginia legislature because they cannot authorize the violation of the state constitution. And here's why. Just as Justice Gorsuch noted in regards to the federal constitution, the West Virginia state constitution provides that only the legislature can enact new law even in a time of war, and that those protections will never be suspended. West Virginia Constitution, Article 1, Section 3. So, while the governor can exercise emergency powers, given his discretion and authority that he was delegated by the legislature, he does have some emergency powers. And really, those should be to suspend law, to suspend occupancy laws, to make things easier for the people to deal with an emergency, not to just create new restrictions. So thus, while the governor can exercise some emergency powers that he was delegated, he cannot act in place of the people's duly elected legislature. And Jacobson does not support the actions of any state governor which are taken in violation of or in absence of state constitutional or legislative authority. Fact is as much as people want to cite Jacobson, or as much as the governor wants to cite Jacobson, there's no federal constitutional source of gubernatorial emergency power. There is no federal gubernatorial emergency power. When federal judges are referring to state governors' actions and their emergency powers, that's assuming that they were delegated those powers by the Constitution and the legislature in that state. And maybe they were in some states, but we're talking about West Virginia, and they were not. It's not. The West Virginia Constitution says that the governor cannot exercise the powers of the legislature. Period. End of stop. And that will never, that provision, that protection of the people will never be suspended. All right, so Jacobson talks about these state police powers, deference to state police powers. And this is, I pulled the actual paragraph which discusses it. This is it at page 24 and 25 of the Jacobson opinion. Here it is. The authority of the state to enact this statute is to be referred to what is commonly called the police power, a power which the state did not surrender when becoming a member of the Union under the Constitution. Although this court has refrained from any attempt to define the limits of that power, yet it is distinctly recognized the authority of a state to enact quarantine laws and, quote, health laws of every description. Indeed, all laws that relate to the matters completely within its territory and which do not by their necessary operation affect the people of other states. According to the settled principles, the police power of a state must be held to embrace at least such reasonable regulations. Here we go. Read up. Somebody read this to the governor. At least such reasonable regulations established directly by legislative enactment as will protect the public health and the public safety. That is directly from Jacobson, and really the only part of Jacobson where they talk about this state police power. They didn't create some new state police power. All they did is say that, well, here's how we're going to measure direct legislative enactments by these sovereign states for the purposes of protecting public health and public safety. So how do we deal with that phrase in what we're facing now? That phrase says by legislative enactment. What part of the governor's stay-at-home order, what part of the governor's mask mandate order, what part of the governor's new enhanced arrest you for obstruction of justice mask mandate order was established by legislative enactment? Not a damn one of them. Not a damn one of them. Yes, maybe they do protect the public health according to our czar and other public health bureaucrats. Maybe they do protect the public health. But you know, there's a lot of things that could be done to protect the public health if that's the only thing that matters. As I've said before, if the only measure of constitutionality or of what we even should do as a country is to survive, we can take everybody over the age of 60 and we can just go ahead and put them in some sort of bubble, or it's sort of like a jail cell. If you go to some of the jails in the big cities, which I did when I worked for the Department of Justice, we would go up into some of these high-rise jails in some of the big old Rust Belt type cities, and they had these nasty old jails that may have been 30 stories high. It was like something out of a Batman movie. And you get up in there and it's dark inside, and you know, it's like it hasn't been. You could go in there and come out, you know, 30 years later. I mean, they're just massive places, and we could convert these big old jails that really we hardly use anymore because they're just, you know, they don't provide the adequate care. That the Supreme Court has come down lots of cases and saying that if you have prisoners, that you have to provide them, you know, all these different services, and that's just not up to par for today's standards. So we could turn these things into just survival units. We can put anyone over the age of 60 in one of these units, and we can make it a little more friendly. We can take, you know, the poop off the walls and take the bars off and then put something just clear. And you can be delivered your food and your water through some sort of sanitized tube, and there will be no viruses getting through, not even, no microscopic particles whatsoever that are coming through these feeding tubes, and they'll keep you alive. Now, as far as whether you'll have Netflix or Hulu or anything like that, we'll have to budget that every year and see. Maybe that'll happen. Maybe it can't happen. But we can keep all of these individuals alive. They can survive. And if that is the measure, if the measure of government's purpose and whatever rights we have accordingly is, a threat of danger and whether government can fix it, then that's where we're headed, because that's logically the end of this road where it's headed to. Thanks for visiting, Jim. The Supreme Court sees differently. Well, Jim, pay attention. I just, the last Supreme Court decision on this issue actually agreed with me. In fact, I cited it in here. I'll go back to it and give you the citation so that you can read it yourself. Where is it? It is no, that's a different one. It is Roman Catholic Diocese of Brooklyn, New York versus Andrew M. Cuomo, governor of New York. And that's a 2020 opinion issued in November 25th, 2020. So not even a month ago. And that's where the Supreme Court struck down some of Governor Cuomo's restrictions against religious assemblies, religious services, and found that even though you have a pandemic, constitutional rights protections are still in place. So where was I? All right, so back to the issues here. While they're fresh in my head, really we have two big ones. So the state issue of whether or not there's a state constitutional violation doesn't apply in federal court directly. So the federal courts generally aren't going to touch that. And this one has already indicated that this court wouldn't touch that issue and sort of tap danced around it and didn't want to get to it. But I would argue that it is a part of the analysis of federal constitutional claims. So what are the two federal that we brought up here in this particular case? And that was the First Amendment, because it was a First Amendment retaliation case. Remember that the way this lawsuit happened is that the restaurant had posted on social media, on Facebook, that they didn't believe in making their customers, their employees, wear a mask, that they felt that it was important. The debate was going on. People were discussing how they felt in regards to these mask mandates around the country. And now we have one in West Virginia. And the restaurant said that, we've given this deep thought, and we don't want to force anybody to do anything. So we're going to comply with all the rules that we normally comply with, and then we're going to make it safe in other ways. We're going to do social distancing, comply with all the other things that they're making us do right now. But we're going to draw a line with this mask mandate. We don't believe in it, and we'll offer takeout services if that's what you want to do. And they suffered retaliation after that by the government, who you had a government official see that and then directly go and tell the news media and tell the client that they were going to comply with this mask mandate from the governor by the next day, or else they're going to get shut down by the next day. No notice, no hearing, no opportunity to be heard, no appeal rights, and nothing. And so when they had asked this government official for where this regulation is, and they just pointed them to the governor's website. And these county health boards, which were really created by the state legislature, they have the ability to pass these local regulations, but they have to follow the process. They have to follow the rules. They have to follow due process, and there's notice and opportunity for comment and hearing and objection and all that. There's due process, but they didn't follow that rule, which very well may have been constitutional, even state constitutional. Instead, they just enforced the governor's mandate, and there was no legislative process in regards to the governor's mandate. There was no due process. And that brings me to another thing that the governor argued here. But I'll get to that. So the First Amendment was, since it's a First Amendment case, we did make the claim that this should be protected First Amendment speech. The Supreme Court has found, and the circuit courts have found, that symbolic speech is protected. Things like, students wearing the black armbands to school to protest the Vietnam War has been found to be symbolic speech, which is protected. Dance performances have been protected symbolic speech, whereas recreational dancing have not been extended First Amendment protections. On the other hand, You have the seminal case from the Supreme Court on symbolic speech deals with burning of draft cards during the Vietnam War. And in that case, the Supreme Court, that's the O'Brien case, found that, or held that, the First Amendment, even if that is symbolic protected speech, the government's interest in maintaining and mobilizing for a war is sufficiently great to override that protected symbolic speech. So now somewhere in that mix of different cases discussing what symbolic speech is and what it's not, and when it's protected, when it's not, now we have, because it's new, like the coronavirus, it's new, it's novel. Now we have one of the biggest political discussions of the day, which are the mask mandates, and the disagreements on politics and science and everything included with a lot of this mandate tyranny, and what the proper role of government is and what the proper role is not to mention the efficacy of all of these things. And of course, that's not been discussed pre-2020 in any cases because it hadn't happened yet. But it has to be argued, and it has to be debated in the judiciary about whether or not First Amendment protections apply to symbolic speech related to these mask mandates. Because the restaurant was taking a symbolic action and refusing to enforce a mask mandate on anyone else in the restaurant. That was a symbolic speech. Now, you can disagree with that. So the First Amendment was invoked here. The United States versus O'Brien case, the case I talked about, the destruction of the draft cards case, that was from 1968. And that case basically handed down 4 different criteria to look at. I'll put this back up. This is where I'm discussing United States versus O'Brien in our response to the governor's motion. But when you actually look at what the court held in O'Brien, because you would think, all right, this would support the governor's case, that a criminal statute banning the destruction of draft cards was perfectly allowable according to the Warren Court in 1968. That didn't violate the First Amendment. But that was a statute that they were analyzing that was enacted by Congress. So when you look at the holding in the case, here we go. All right, so the court held that we think it clear that a government regulation is sufficiently justified if it is within the constitutional power of the government. Okay, that's factor number 1. You have to get through that before you get to the other factors, which are whether it furthers an important or substantial government interest, if the government interest is unrelated to the suppression of free expression, and if the incidental restriction on alleged First Amendment freedoms is no greater than essential to the furtherance of that interest. All right. So on the other factors, of course, they're going to be able to show through the affidavits of the COVID czar and all that, yeah, there's this great government interest out there, that they are taking actions, that are aimed at that. They're not aimed at, suppressing free speech. But here, the first factor that they have, the first hurdle that they have to get past, we think it clear that a government regulation is sufficiently justified if it is within the constitutional power of the government. So, was the mask mandate in Executive Order, what was it, 5020 or 7720, whatever, of Governor Justice's executive orders, one of the 100 or so executive orders he issued this year, is the mask mandate sufficiently is it within, quote, the constitutional power of the government? What is the constitutional power that it relies on? Well, there is no federal constitutional power that Jim Justice was relying on. if you look at his actual executive orders themselves, they start out, pursuant to the governor's declaration of a disaster under West Virginia Code 15-5-6. He's allowed to control people going in and out of disaster zones, basically. I'm paraphrasing. So that is the authority on which he relied on to issue the lockdown order, the stay-at-home order, the mask mandate. So it's a West Virginia Code statute. Who passed that? Who enacted that? The West Virginia legislature. What can the West Virginia legislature not do? Violate the West Virginia Constitution. So therefore, even if the West Virginia legislature said, all right, Governor, we're going to allow you to pass any new law you think is a good idea, so long as it's a time of emergency and you declare that there's a declaration of a state of emergency, if that violated the Constitution, if that tried to convey their legislative authority to the governor, where the governor now is acting both as the legislative branch and the executive branch, which has been happening for 10 months, that is being taken in absence of any constitutional powers authorizing it. That is not a constitutional power. That's a statutory power, and statutory power can never abrogate a constitutional power. A state only a constitutional amendment can change the state or the federal constitution, not a statute. So here's the big thing that courts have been ignoring, and people like the governor have been missing, including his lawyers, is that it's not within the constitutional power of the government. If you don't get to that step, you go no further on the constitutional analysis under any of these cases. And that's United States versus O'Brien. But Jacobson talked about the separation of powers. But here's the point, is that it can't be sufficiently justified if it's not within the constitutional power of the government. So yeah, it's not the strongest First Amendment claim that's ever made its way through the federal judiciary. But what this has going for it is that it's clearly the actions of a tyrant. It's clearly the actions of a governor who's acting just because no one else has stopped them. Just because no one else has stopped them. In fact, in our first lawsuit directly before the West Virginia Supreme Court, that was their argument was, well, Congress or the legislature can stop us if they want to. They can call themselves into session with a 3/4 supermajority. But they haven't done it. And because they didn't stop us, then that must mean that it's constitutional, right? No, wrong. That has nothing to do with it. There's no constitutional analysis that just says, well, as long as nobody tries to stop them, then it's probably constitutional. Also, on the First Amendment, I cited the Tinker case, another Supreme Court case from the next year, 1969. That is the armband case, another symbolic speech when students were wearing black armbands protesting the Vietnam War. And then that's a case in favor of the First Amendment. The court ruled that public school officials, and I think this is relevant given what's going on right now, public school officials cannot censor student expression unless they can reasonably forecast that such speech would substantially disrupt school activities or invade the rights of others. All right, so what's going on in schools right now? The governor is not just our governor, but all over the place. I mean, that's exactly what they're doing is they're stopping expression of any sort by students. They're not even letting them go to school. I mean, one could say that the governor is substantially disrupting school activities himself. One could also say that he's invading the rights of others himself. All right. Tinker, in that case, here's what's interesting if you're in West Virginia and you hadn't heard of this. West Virginia versus Barnett. They cite West Virginia versus Barnett. And that's a United States Supreme Court case from 1943, which held that under the First Amendment, a student in a public school could not be compelled to salute the flag. So, the 14th Amendment, as now applied to the states, protects the citizens, and obviously this was right during World War II. Protects the citizens against the state and all of its creatures. And what a great quote, because the government does have a lot of creatures, metaphorically and literally. Boards of education, not accepted. These have, of course, important, delicate, and highly discretionary functions, but none that they may not perform within the limits of the Bill of Rights. When do we ever read stuff like that now? The Bill of Rights mean nothing now. But here, these seminal cases that they still have to point to, they have language like this. The government may not perform, none that they may not perform within the limits of the Bill of Rights. They're educating the young for citizenship as reason for scrupulous protection of constitutional freedoms of the individual. If we are not to strangle the free mind at its source and teach youth to discount important principles of our government as mere platitudes. Again, a great quote, and this one came out of West Virginia. So, silent acts of physical expression, that's what was happening in West Virginia, the not wanting to salute the flag. Silent act of physical expression. It was symbolic speech. It was entitled to protection. Even where the authorities told the courts that there was going to be all this harm that would ensue. All this harm that would ensue from a student doing this. In fact, the school authorities said that they had fear from disturbances of the students wearing armbands. But the court found that undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any words spoken in class, in the lunchroom, or on the campus that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says that we must take this risk, citing the Terminello case. And our history says that it's this sort of hazardous freedom, this kind of openness, that is the basis of our national strength and of the independence and vigor of Americans who grow up and live in this relatively permissive, often disputatious society. So, again, we don't hear quotes like that anymore coming from the Supreme Court. You don't hear the government giving us any quotes like this. We don't hear anything about the Constitution compelling us to take risks, and about hazardous freedom and openness, and that being the basis of our national strength and vigor. No, now we're told that because the UK is doing it, or because France is doing it, that we must also do it. That we don't believe in science if we're not doing absolutely we can to protect the public from this virus, even if it means shutting down 1/3 of our small businesses or 50% of our small business restaurants. The fact is even the Supreme Court in past years has acknowledged that with liberty comes safety risks, and that is part of why we're so strong as a country. All right, so that's the First Amendment argument. The stronger argument here is 14th Amendment due process. All right, so the 14th Amendment due process clause, I mean, it's a lot of different things, but that's where the Supreme Court has pulled so much of its legislation from the bench. For instance, abortion. Where does abortion come from? The right to privacy. Where in the Constitution or in the Bill of Rights does it mention the right to an abortion, or the first trimester, second trimester, all that? It doesn't. It doesn't say it anywhere in the Constitution. The fact is that past Supreme Court justices have created that right, that constitutional right, using the 14th Amendment. So 14th Amendment substantive due process is new laws that aren't specifically said in the Constitution, but which we sort of imply that they must be there. Procedural due process is the right to have notice in a hearing before the government deprives you of something, life, liberty, and the pursuit of happiness. So what do you have the right to? What is your life, your liberty, and your pursuit of happiness? What rights do you have? That's substantive due process. What does the government have to do to take your life, to take your property, to take away your ability to pursue happiness? That's procedural due process. Well, notice and a right to be heard, some sort of ability to appeal it. One of the big things here, there's two arguments. One is that, believe it or not, the governor has claimed that there is no protected right to have a small business and operate your small business. So applying to this case, if you're a restaurant, the government or the governor can step in and close your restaurant, close your business, and they can do so with no notice, no hearing, no right to appeal, just, so long as they have some sort of health related reason to do so. That's it, because there's no federal right. Life, liberty, and property does not include being able to open the restaurant that you've spent years building, invested in, and that your employees, your customers, your partners, your investors, everybody depends on cash flow from customers coming in because you're able to open the restaurant. But that's not property. That's not property. That's just evil profits. Those are profits. You're not entitled to profits. There's no life, liberty, and property doesn't include profits. Now, that's what the governor has argued here. Life, liberty, and property does not include the ability to run your business, your small business, because that's like saying you're entitled to profit. Profit's evil. You're not entitled to profit. That's the argument the governor's made here. And so what I did is correct the record. The Supreme Court has said many times, and again, if they want to go back to 1905 for the Jacobson case, the Supreme Court said many times that business, the right to engage in business, is a federally protected right under the 14th Amendment. If it protects abortion under the guise of life, liberty, and the pursuit of happiness, well, it just has to protect your small business from just unilateral closure by the governor and executive order. It just has to. But that's the argument that they've made, is that there is no right to engage in business because that's just profit. Yeah, if we take your business real estate, then yeah, we have to give you due process. But if we just take your profits, then we can do that whenever we want, for whatever reason we want, because that's what we do. So I went and looked up the definition of the Supreme Court cases saying that there is a property interest in your business assets and your business goodwill. So it doesn't say anything about profits. So I looked up the definition to assets and to goodwill. So assets, property of all kinds, real and personal, tangible and intangible, including, for certain purposes, patents, causes of action, which means lawsuits, which belong to any person, including a corporation or the estate of a decedent, the entire property of a person, association, corporation, or estate that's applicable or subject to the payment of his or her debts. It's a pretty broad definition. So the Supreme Court's also said that goodwill is included. Definition of goodwill, and these are from Black's Law Dictionary. That's usually what courts use. Goodwill, and this is a broad definition, and this has got to include, if they can't deprive you of your business goodwill without due process, this has got to include restaurants. Goodwill, the favor which the management of a business wins from the public. Let me put this up so you can follow along. Goodwill, the favor which the management of a business wins from the public. The favorable consideration shown by the purchasing public to goods or services known to emanate from a particular source. The custom of patronage of any established trade or business. The benefit or advantage of having established a business and secured its patronage by the public. So if you're a restaurant, you've put a lot of time and investment into the business before you ever get any profit, any return. I mean, you've bought the business or leased the building, you've redecorated the inside, you've put in the kitchen fixtures, you've hired staff to put in place. I mean, you've repaved the parking lot. I mean, you have all these investments before you even open. So maybe you've spent millions of dollars before you even serve the first customer. So you then, after you open, you develop a clientele. You got people who keep coming back, and after a period of time, I mean, most restaurants fail, right? According to a lot of what I've heard, but some are very successful. And the ones that make it, the ones that are successful, and they say they've been there for a year and or 2 years or more, they have an expectation at that point, I would argue, that they know that if they open a restaurant tomorrow, just like they did last week and the week before that, they're going to make X amount of dollars. They might make more, they might make less, depending on, maybe it depends on the weather or some other factor. But they have an expectation that there's going to be some amount of cash flow that comes in just based on the fact that they opened the restaurant that day. And that's how they run a restaurant, as many other businesses. It's a day-to-day cash flow business. So after a period of time, your goodwill increases, your customer base increases. Continuing on, as property incident to a business is sold, favor vendor is won from the public, and probability that all customers will continue their patronage. It means every positive advantage that's been acquired by a proprietor in carrying on his business, whether connected with the premises in which the business is conducted or with the name under which it is managed, or with any other matter carrying it with it the benefit of the business. So obviously a lot of the goodwill stuff is for contracts for selling your business. If you're buying somebody's business, you're buying the goodwill. In other words, the expectation that these patrons are going to continue coming because they've been going to this restaurant for the past however many years. And you've looked at the books to see what kind of money that's brought in. And so that's part of what you're buying, is this goodwill and this expectation that this patronage would continue. And people may have invested a lot of money into that. So how do you square that definition, and as applied to restaurants especially, with the governor's argument that restaurants are powerless to complain if he wants to close them at his whim? Powerless, because there's no 14th Amendment due process right. If you're a restaurant, you have no expectation of profits. I don't think it squares at all. In fact, the U.S. Supreme Court has held several times that there is a right to pursue or operate your business. Several circuit courts have had opinions on this. Second Circuit, 1969, United States versus Tropiano, which held the right to pursue a lawful business, including the solicitation of customers necessary to the conduct of such business, has long been recognized as a property right within the protections of the 5th and 14th Amendments. Some other cases, Small versus United States, 1964, and there is a Fourth Circuit case where we are in West Virginia from back in 1990, and this went the other way, but there's something to be learned from that. So the Phantom case said the mere denial of a business opportunity without more. So just that you're denied a business opportunity without more facts, such as deprivation of an existing business benefit, like continued patronage, I would argue, or entitlement, does not deprive a person of property or liberty interest. So what's the point? And there's more case law on that. So what's the point? So if there is no 14th Amendment substantive due process right to keep your restaurant operating, what does that mean? That means you're not entitled to any due process. The government can come in and shut you down without giving you notice or right to a hearing, anything. You opportunity to be heard. Basically, how they treated my client, the restaurant in this case. That's the argument here. That's coming from the governor. That's the argument that he can shut you down, and there's nothing you can do about it. Nothing, because you don't have a life, liberty, and pursuit of happiness, life, liberty, and property claim in being able to open your restaurant. You can invest in it, you can build it, but you have no right to profit. So therefore, I can close you down and say you can't open. Now, for the reasons I explained, I think that's wrong. But what's the other argument that the governor brings forward? And a lot of other people have had this argument. I've explained this, and I think most of the radio interviews I've done on this topic. All right, Mr. Bryan, well, how do you explain this? Well, you follow the seatbelt laws, right? And the speed limit laws. Or if you're a restaurant, you already have no smoking laws. You may have other licensing or health code regulations that you follow, and if you don't follow those, you get inspected. They come and shut you down. How do you square that with your arguments here that you don't have to follow a mask mandate? And to which I respond, well, that's a great question. Let's look at the differences. What are the differences between those things that you brought up? Say the no smoking ban in restaurants, or the requirement that chicken in a freezer be kept at X degrees Celsius, whatever. Or else they can take action against you, shut you down, revoke your license, whatever the case may be. How do you square those two things? Well, let's look at the no smoking ban. All right, so where did that come from? Well, that came from the local county, let's just say Putnam County, West Virginia Health Board voted back in 1997 or whenever it was to ban smoking on all restaurants within Putnam County. That then joined the other regulations that they already had duly enacted that they're going to inspect you for, and if they see people smoking in there. Now, back in 1997 or whenever that was that they enacted that, they followed the requirements that the legislature had set in place. They had notice of this new rule that they were going to come up with, and there was an opportunity to comment and be heard and attend the hearing and to object. And you had the opportunity to appeal it and litigate it. And that, in fact, it was. There is a West Virginia Supreme Court case where a restaurant was challenging the constitutional ability, the state constitutional ability of the local health department to ban smoking in their restaurant. And the state Supreme Court said, well, the legislature created these boards of health and they tasked them with coming up with these rules for, health code rules for these restaurants that would be enforced. And you had the opportunity to participate in that process. In other words, you had due process. So you had due process. There was a process. And there was a authority set in place by the legislature to create health rules. This is not just any law you wanted to create. These were for regulation of restaurants, and that was found to be constitutional. And let's compare that with what we have here. Here, we didn't have the Putnam County Board of Health doing the same thing with masks. They didn't propose that we have this new rule. They didn't have the opportunity for comments or the opportunity to have a hearing or come in or object or comment or argue about it or even appeal it in litigation to the state Supreme Court or to appeal any closure or punitive sanction that you had. None of that was there. In fact, they wouldn't even give my clients anything in writing. They just said, well, you can just check the governor's website, which may be different today than it was yesterday. We don't know. That's not due process. That's not due process. Even assuming that the legislature passed that law and it's enforced in the same way, there still wasn't due process because there's no notice. There's no right to be heard. There's no right to appeal. In fact, if you look at the governor's response, this is just really telling. Not that one. Bring the governor's response back up. All right, so here's the governor's response. I think it's down at the bottom. Oh, not that one. All right, here's where we're talking about assets and businesses. All right. All right, but here is where they admit assets of a business, including goodwill, unquestionably are property under the 14th Amendment. But they say they didn't take property, they took business. See here? Business, in the sense of activity of doing business or the activity of making a profit, is not property in the ordinary sense. So I explained the flaw in that argument, but that's their claim. All right, here we go. The idea, remember they called this small business. How dare you? Try to stand in the face of us stopping Pearl Harbor. The idea that the governor could be obliged to provide a hearing to every restaurant or person affected by an executive order in the face of a global pandemic is at best a misunderstanding of the law and at worst a disingenuous waste of the courts and counsel's time. That's their argument. That's where they leave off on really the most important discussion there of whether the government can close a business with no due process, or whether they have to give some due process, because you do have a right not to be unilaterally shut down like that. That's their biggest response, is that the mere idea of this small business, even bringing this up, asking, even obliging to ask for a hearing for every restaurant they shut down or affect because there's a global pandemic. It's at best a misunderstanding of the law, and at worst a disingenuous waste of the court's time and of counsel's time, meaning the lawyers for the government. So that's how much the West Virginia governor cares about you, small business and small family-owned restaurant in West Virginia. That's how much they care about you. They can't be bothered to be asked for even a hearing for any restaurant that they shut down pursuant to an executive order, because you have no right to get a profit out of the restaurant that you created. You have no right to a profit. Profit's not an asset. I mean, that's literally the argument that they've made here. And they won't advertise that, and the news media won't report that. But that's what they're seeking to enshrine as law here, and as precedent to follow again in the future, is that if you're a small business, you can be shut down. Do you think that would happen with Walmart or Lowe's? No. Why do you think that they're so quick to jump on the bandwagon of not only enforcing what the mandates are, but to aggressively enforce it and to do more? And by the way, there was a case from Walmart in the news here a month or so back that I'm going to be bringing up. And I don't want to talk about it yet because I'm trying to get one thing first. But stay tuned. If you haven't subscribed to the YouTube channel, make sure that you subscribe and click the little bell thingy to be updated when I go live with updates. Because sometimes, well, actually, if I do my intro that has any guns in it, YouTube, I think that they use the algorithm that suppresses the notifications so you won't hear them anyways. Mitchell McNeely, I've been smoking 10 cigarettes a day since I joined the Army at 19. I took every PT test that they gave me while smoking a cigarette and passed with flying colors. Well, I guess Mitchell, they said that, you had the opportunity to complain back in 1997 or whenever your county outlawed smoking, and too bad, so sad now. But isn't that the point? Is there any science behind let's say any of these bureaucracies that get involved in our life. My favorite one to choose here is like the West Virginia Board of Barbers and Cosmetologists. Have they ever done anything worth however many six figures we're providing out of taxpayer money to fund that office? Have they ever saved one life? Have they ever saved anybody from some evil barber? And if there was an evil barber, could they have stopped them with their little rules on every little thing that they have, and their yearly fees and all that stuff? Has that ever had any purpose? No. Are there states out there that probably don't even have this agency, and people have survived just fine? That do you think that any of us are smart enough to be able to evaluate the risk of using a certain barber and then either assume that risk or go to the other barber down the street? No, we're not that smart. They have to protect us from the evil barbers. It's not that we can't sue the barber anyways if they screw something up and they slit our throat on accident. It's not that we can't already get justice. We can't, we can file a lawsuit and get money damages, but we really need this bureaucratic board of government employees who are all deemed essential, who will never have a salary reduction, who get fantastic health care that the barbers don't get. We need to really have them in place just to make sure that these barbers know the rules. And so that when you walk in, you know that you're not just going to get the haircut that you want, but that you're going to survive the process. The fact is we could probably survive without 90% of the bureaucracies that we waste money on. All right, it's a pandemic. Let's go through what business, what public jobs are essential or non-essential. Let's look at all these water boards and all these different things and say, all right, are you essential? Or are you not essential? Let's bring in the two Bobs. So what is it that you say you do here? So the point is that government will always grow itself, but we need to get back to freedom. And I think a lot of people have seen that during this difficult year, we've forgotten how important our individual liberties are, because we saw them get taken away, and we know that they can get taken away again and even worse next time. And depending on who's the governor or who's the president or whomever you've set the precedent for, we don't know what they're going to do, because there's going to be different people in with different motivations. So we have to protect it all the time, every time, or it's never going to be there for us. And that's why freedom is scary, because you have to deal with the scary in order to have the freedom. And really, that's just a facetious saying to educate your neighbor on why he needs to be okay with 80% firearm kits out there, or bump stocks, or pistol braces on AR-15s, because although that might subjectively scare you, if we let the government ban those things, or if we let our legislatures ban those things, we let our fellow citizens ban those things under the guise of safety, then we also pre-authorize all sorts of coming attractions, preview of coming attractions. So that's why freedom is scary. So I appreciate you for listening if you've made it this long. But those are the two issues that we have fired back immediately at the governor with on the First Amendment discussion. And also, most importantly, I think the 14th Amendment due process discussion, because that applies everywhere. We don't need to be allowing governors to shut us down ever again, to lock us down without due process of law. What else comes with that? And why are they fighting this again so hard? What happens if we establish that we have a life, liberty, and property interest in being able to have our small businesses? Well, what's the government going to have to do next time, and also last time, for shutting that property interest down with no due process. When they deprive us, just like when they put a highway in through your property, they can do it, but they got to compensate you. And that's what they need to do. And that's what they're trying to avoid to do. They don't want to compensate us for what they've taken away, except here's $600. Here's $600. Yeah, we spent $3 million on building this restaurant, and 3 of our investors are now forced into bankruptcy. But yeah, thanks for the $600. So thanks for watching, and I'm sure it's dinner time for me now. But make sure that you subscribe, or if you're on Facebook, follow so that you see, and go to civilrightslawyer.com. That's the website where I post all the updates, and I'm going to upload these documents to the website probably tomorrow morning if you want to review them yourself. So stand by. I'll update on this topic when the court issues the order. I'm not optimistic about it, because if you watch the video following that hearing, the federal court wasn't real excited about our complaints about the mandate tyranny, unfortunately. So we're going back, regardless of what happens here, we're going back to state court. We're filing a lawsuit in state court. If you want to know how you can help, there was a GoFundMe that did very well. We're finally the client's about to get the money from GoFundMe. It's been a hell of a problem. So I set up a new link for the client's donation to the client's account, and you can find it on the civilrightslawyer.com, or in the description of this video is the link to it. And that will go directly around GoFundMe, so they won't be able to judge us and decide whether or not they want to make it difficult for us. So again, thanks for watching, and I'll see you next time.